statute book. In spite of that, applying this Honorable Supreme Court decision, please notice, we are of the view that the law laid down by the apex court is clear and categorical to the effect that the upper ceiling of 50% vertical reservation in favor of SCs, STs, OBCs should not be breached in the context of local self-government. Exception can be made only to safeguard the interests of SCs, scheduled tribes, in the matter of their representation in panchayats located in the scheduled areas. This is applying Rakesh Kumar of the Honorable Supreme Court. Only exception is STs. This is one of the specific enumerated conclusions rendered by the Constitution bench after stating to the said effect in paragraph 64 at page 227 of the judgment in K. Krishnamurthy, wherein the apex court had clearly taken the view that there cannot be any vertical reservation in excess of what has been noted above. It has also to be noted that K. Krishnamurthy was decided making specific reference to the Constitution 73rd Amendment and the Constitution 74th and the statement of objects and reasons of those amending acts. Considering the submissions of the learned special GP on basis of OBC population in the state of AP, this was also...
One minute.
This is done, presented by the government, presented by the government. No action can be the question of implementing it even this is what is history. States that is. Then we can go into the subject. Correct. So otherwise it will come.
Yes, Advocate General. How do you overcome this section 200 of
Article 200.
Constitution, Article 200? Yes, Advocate General.
200.
Yes.
This your argument is this Telangana backward class reservation so and so bill 2025 has been sent for assent of the governor, no, that
Not the backward classes, madam. The backward classes has recommended that it be increased.
no
By
this
what
bill
clause?
is
Yes,
pending
yes,
consideration
yes,
of the
yes.
governor.
Yes.
Now, what is the process involved now?
The governor should assent. I'm glad your lordships are agreeing.
Maybe Advocate
Yes,
General.
madam.
Mr.
Assent is mandatory.
No,
Yes, Advocate General. What
Yes,
is your
madam.
article?
Unless the
One
learned
minute,
advocate-
sir.
Yes, madam.
He's asking, just wait.
How do you
Lord.
get up this Article 200, sir?
My lord, the assent, your lordship will please to see that was the very same assent of bills was an issue before the Supreme Court, my lord. Justice Pardiwala said, my lord, in the event, Justice Pardiwala said, in the event that it is held for more than 1 month in certain cases, 3 months in certain cases, it should be deemed that the assent is given. My lord, in this case, assent is given, my lord, insofar as reservations are concerned, at 42% by the.
But you should have said so. You should have said so in the GO itself, no? That we have sent it, we have waited for 1 month. That in view of the latest law laid down by the Honorable Supreme Court, it is deemed assent.
1 month also has not
My
passed.
lord, as far as I know, it is.
This is a precise question we are asking in your support. What is?
Please wait.
1 minute.
My lord, my lord, not mentioning in the GO, my lord, I humbly submit to your lordship that not mentioning in the GO itself, my lord, does not make the GO any infirm, my lord. That's the.
Maybe right, maybe right.
My lord,
Whether that 1 month time is over or not, that is also not over, no, sir. That's all difficult.
Even 1 month is not over.
more than 1 month is over, my lord. We'll make our submission. That's
No,
my
no.
primary
1 minute,
submission.
1 minute. We are not saying anything. In order to understand the case, we are putting some questions. That doesn't mean that we are against you or for them,
No, no,
or they
no.
can't say that we are against them or for. Not like that.
Right.
In order to.
My lord.
Lord, in our writ petition, page 84, there's a bill.
My lord, we make a request, my lords, for your lordships to have it immediately after vacation. They cannot be
For AG's convenience, at page 84, we have put the bill, my lord, in the second writ petition.
Is anyone having the copy of the bill?
Yes, my lord, page 84 in the second writ petition. AG can also refer it, learned AG. For your reference, just for a reference of all of us. Page 84,
Yes,
exhibit P6.
It's 3 months, my lord, not 1 month. I've read the judgment, it's 3 months.
That is 31st August 2025, this is in assembly. And thereafter, I am told legislative assembly it has taken next day.
yes, this is for local bodies, sir.
Yes,
They have
both are.
sent it. Where is the question of?
It is,
Panchayat is at page 90. Panchayat is page 90. We have not filed local bodies. Municipalities, then Panchayat is at page 90, my lord. Same date, 31/8/2025.
Ayur, let us say,
So 1/9,
oh,
it's absurd, my lord, to say that 1 month and then say this is the law. Can it be said like that? And one more thing, my lord, this is what I'm trying to submit to your lordship. The honorable division bench of this court, while holding 34% is not to be allowed, apply the honorable constitutional bench.
Yes, argue on this page 94.
Yes,
Yes, let the learned advocate general answer. Yes, Mr. Sudarshan Reddy. Mr. Sudarshan Reddy. This, see the bill, page, you have presented this bill.
There are
Yes,
two bills.
to
One,
amend section 285A of the Panchayat Raj Act.
my lord, one bill is
Yes, sir. Governor's assent is pending consideration of governor's approval. Where is the question of going ahead with this?
my lord,
Okay,
may my submission before the lordships would be, if it is refused by the government, it stands
No,
on
no,
a,
no.
it stands on a
Where did you
different.
say that? Where did you say that in the GO now? Where is the, see, this is, as a policy decision, you have conducted you have collected empirical data. BC Commission, dedicated commission has conducted inquiry.
Yes.
Population, according to your data, is 53 point so and so. You have decided to enhance reservation to 42%.
Yes.
Yes, you passed a general, you wanted to pass a general law. Bill is presented, unanimously approved by both the houses, pending governor's assent. Where is the question of going ahead with this? How can you issue this GO now?
My lord, in
No,
circumstances.
it has not even become a law now.
In circumstances of this nature, my lord, if the governor refuses, my lord, it stands on
No,
a
no,
different. Well,
this
I bring
bill itself is for amendment of what? This section 285
that's the reason, my lord.
for
If it-
increasing the cap.
in the event, my lord, the governor were to refuse it, it stands on a different footing. When it is pending with the governor, my lord, I would make my submissions before your lordship.
Show
On
me,
the or
show-
any your lordship has. my
please
lord,
show us any judgment which says pending assent of the governor, you can go ahead
this
with
is a house
implementation.
motion. This is a house motion which is moved before your lordship.
This
Me
is
to
only-
argue, my lord, as if it is a final hearing would be a difficulty, my lord.
Mr.
I'm-
Sudarshan Reddy,
To stand that.
there was some constitutional restriction because of law laid down by Supreme Court.
No, my lord, even the Supreme
Restricting
Court, my lord, even the Supreme Court.
Reservation, please, 1 minute. Because of law laid down by Supreme Court in Indra Sahni's case and subsequent judgments,
Radhakrishnan.
ceiling reservation to the extent of 50%. Now you have decided to amend section 285A of the Panchayat Raj Act 2018. Yes, you have presented the bill. You have sent it for the assent of governor. Governor has not given assent. So where is the question of going ahead just because High Court has, and you say here, Honorable High Court of Telangana, its common judgment dated 25/6/2025, WP number 2661 of 2024 and corrected cases, has directed state government to complete. For the sake of complying with this order, you will now go in a post-haste
On
manner
that, I wish to
and
add,
see pending assent of the government. Can you go ahead?
wish to add something. The
things,
direction is to complete the election process, not this process of
One minute.
reservations.
No, one minute. You
No,
can-
without the
one minute,
Supreme-
one minute. You have two alternatives, Advocate General. You must at least go and file extension petition in that writ petition number 2661 of 2020.
No, that's what I'm clarifying. For a moment before he answers, I just need to clarify.
Filing it
One
on the
aspect,
reopening
Advocate General,
day.
just a minute. Because the bench never said that await the reservations. Because the Supreme Court said that if the reservation, this thing can't be done, you proceed with the existing list. That is settled law. That is settled law. So therefore, the bench never gave this time to enable them to complete all that exercise. Irrespective of that, they must hold elections.
No, they can seek.
Today,
extension
they
of-
can't
no, no,
take shelter
one-
from
one
the-
minute. They can file an application seeking extension of time.
That they could have taken, no,
No,
notwithstanding
one
that.
minute. What is the stage of that before the governor? Anybody can throw some light on
That we
that?
probably we
I
cannot.
believe he has sent it to the Honorable President, my lord, for clarification.
What is the stage?
With the President.
What is the stage before?
You can't be saying that.
Huh?
My lord,
No, probably none of us.
No, Mr. Vidyasagar, you please inform this court pending assent of the governor when they have passed a bill. Governor's assent is pending. Where is the question of can they issue this GO? Please inform.
Does it become a law?
No, you as an officer of the court, you please guide the court. You
Independent of the.
1 minute, 1 minute. Yes.
Constitutional mandate.
Can they do this?
There is no reasoning given in the GO.
Forget, please answer our question. Can they do it or not? Our prima facie opinion is they cannot do it. Please tell us.
Unless the president assent is, or governor assent is
Yes,
deemed.
they cannot do it.
There is one aspect. Suppose if you want to really increase to 42%, then file an extension application in that writ petition that is 2661 of 2024 seeking some 3 months time. So that pending assent of the government, postpone these things. So we'll not comment anything on this. You file an application in the 2661 of 2024 saying that you can seek another 3 months time in view of the latest judgment of Supreme Court, whether it has become final or not final. Because again, presidential queries are there before the before the Supreme Court, whether
Matter is
Supreme Court can give a directions to the governor and all those things. That's an issue. Now, as on today, 3 months time is prescribed in your one particular judgment. If it is not given any assent, then it is deemed to be law, right? So you file an application seeking extension of time by 2 months, events are not going to fall. Your decision to increase to 42% also will be sacrosanct. The way you want to do it, you can do it. But it is not even 1 month pending before the governor. No, that's the point.
Wait.
My lord, the whole submission before your lordships, my lord, if your lordships, pardon me, my lord, if your lordships could have it after vacation, our
No, that-
submission,
one
my submission before your lordship.
No, 1 minute. If you want to get instructions, get instructions. We'll have it tomorrow.
Not tomorrow, my lord, your lordships may have it on the reopening day, my lord. It can't be, my lord, there can't be an urgency in a matter where, my lord, a welfare,
Please,
my lord,
we are not coming in your way in increasing the reservations in respect of BCs from 25 to 42. But do it in accordance with law, no. You go and
we'll bring it to your lordship's notice, my lord. We'll satisfy your lordships. My lord, a welfare legislation of the state, my lord, cannot be, my lord, your lordship may pardon me, cannot be interfered with.
That goes to the root, no. That goes to the root. Because without there being an enactment, how can you go in anticipation of something?
There are two things, my lord, which I would like to bring to your notice. One, my lord, the amendment which was made and my lord, the act which was made, the legislative competence of the state is there. My lord, when the legislative competence is
No
there,
doubt, sir, that's there. Your bill is there, it is pending assent, it has not
Thank
been.
you, my lord, your lordship may kindly, my lord, legislative competence of the state is not in question. My lord, the legislative competence is there and that legislation is passed unanimously.
Unless it is accepted by the governor, it will not become the law, no.
My lord, I'll
No,
bring that to
law
your lordship.
to implement.
My lord, in circumstances of this nature, my lord, where there is a legislative competence with the state, my lord, which is clear and my lord, which is not in dispute that the legislative competence is there, my lord,
Not
a
like
mere
that, senior. Not like that, senior. Try to understand.
mere assent of the president or the governor, my lord, is not an issue, my lord. It does not debar the state from making a law accordingly. My lord, a welfare legislation cannot be interfered with, my lord, by way of a house motion, my lord. Your lordship may pardon me, my lord. A welfare legislation cannot be interfered, my lord, by way of a house motion, my lord. Your lordship may hear it, and my lord, your lordship will take a decision on that. Nothing hampers, my lord, between
No,
today
no.
and
1 minute, 1 minute, 1 minute. If elections are not conducted before 30th September, events are not going to fall. You are conducting elections just because of an order passed in petition number 2661 of 2024.
we are very my lord, from the honorable courts, my lord. We are very
2 years.
1 minute, sir. There are so many instances, state has come and filed extension application to conduct elections.
right to file it also, my lord.
Right, you can do that. So you can see, because 1 month time is almost over, as on maybe by 30th September, 1 month will be over. You can conduct elections in the month of November after 3 months time, if whatever the law is laid down by the Honorable Supreme Court, right? So after 3 months, you can come up with an argument. We have waited patiently for 3 months. Now that governor has not enacted, I mean, so it becomes a law. So if you conduct elections, you're in the month of November, two objects you'll be achieving. One, you will be complying the law. This is subordinate legislation. The main legislature, that is 285 itself is not amended. There's a question of acting on this is a question now. Now, you'll be complying 42% also if you wait up to. Have patience. If you want to do something good for somebody, you must wait. You must follow the law. Then nobody can question you. That's the point. Now what happens is, only for something you say, yes, we are, no, 1 minute. Only to say, yes, we have given 42%, it is courts who have interfered. Don't say that, because if you want to really extend that 42%, follow the law. Just wait for 2 months. Events are not going to fall. Conduct elections in the month of November or December. That's it. By which time you will be complying the 3 months period of latest Supreme Court judgment. And if the governor doesn't give any assent, also it becomes a law. Then you can act upon.
Yes.
My lords may kindly have it after petition, my lord. We would like to satisfy your lordships on that aspect also. My pleading before your lordships is not by way of a house motion, my lord. A law made by.
Suppose election notification is issued, then writ petitions cannot be entertained.
Even
That's
then-
the law of the land.
That's
Only
the
election
problem.
petition, that's
My
all.
lord, the arguments which are now sought to be put forward by the petitioner saying that it is a constitutional violation, your lordships can look it at any stage. My lord, it can't be.
Once election process starts, we are precluded.
Mr. Sudarshan Reddy, when parent legislation is pending assent of the governor, where is the question of subordinate legislation?
My lords may kindly allow me.
Please answer this point actually if you want.
That's the very query I am answering, my lord. My lord, two things, my lord. How do you look at a legislation my lord, it's in the constitutional framework. First, my lord, whether there is legislative competence for the state. My lord, the legislative competence. My lord,
You have given reference, please see page 30, you have given reference of pending bill.
That's
It
what,
is
my
the
lord.
bill, based on that bill you are issuing the subordinate legislation.
I'm not, my lord, your lordship may give me an opportunity to make my submission at once.
No, you please give us assurance. Either you defer the election process, if you do not want us to interfere, please give us assurance that you will defer. You will not interfere, but
Not interfere.
You-
You will not interfere with your GO 9. Only thing is, if you want to get instructions, we'll have it tomorrow. Just come back.
Maybe tomorrow, my lord. Your lordship may have it on Monday, my lord.
No. By then they'll bring in the notification.
You have instructions?
Yes, Mr. Sudarshan Reddy, anyhow, Dasara vacations are there. we don't think you will go ahead with the election. You give assurance that you will defer the election process for a period of 10 days. We will hear the matter after vacations. Defer the election process.
I cannot give an
election notification? Are you issuing any election
The
notification?
moment the state government gives a concurrence, I have to issue the notification.
When they are giving the concurrence?
But when they give the concurrence.
No, can you wait for up to 6th?
But as per the mandate given by the Constitution and the Panchayat Raj,
No.
I am required to conduct.
1 minute,
the
sir. Advocate General, you are not coming in your way of enhancing the reservation. Follow the law and do it. This kind of thing, suppose if we stay this or set aside this, then it becomes a problem. The purpose for which you have undertaken so much of exercise by appointing one-man commission and all those things, and the effort made by that one-man commission will all go in waste. You must also understand. So, you get instructions that you are not going to act till 6th, then let the regular bench hear the case, because your object appears to be very noble, depending upon the population you want to increase and all those things. Maybe that is the policy of the state government. But it should be enacted first. Last 285A has to be amended. Then you can do whatever you want.
And the judgment.
1 minute, sir. What is it?
May I just say something on facts? Ma'am? Something on facts. This is the Advocate General and also the election, my friend. Last-
I have not been asked. My
I'll just
question-
say something, then Advocate General can respond. Mr. Advocate General, just a minute. Lord, whenever we were requesting the Election Commission to go ahead with the election process, their stock answer was that unless the state government gives us a concurrence, we cannot do anything. So if they can defer the concurrence till for a week's time, nothing is going to happen.
Let the regular bench decide. As a council,
Because
you
Election
did-
Commission
1 minute,
awaits the
1 minute,
concurrence from the
1
state
minute, 1
government.
minute. As a council, you did not give any undertaking. You get instructions, if you want, we'll hear the case after 15 minutes or 10 minutes, so that you can get your instructions from your respective clients. Then take a
They
decision.
need to make arrangements and get concurrence.
My lord, before that, my lord, to the queries put by your lordship, my lord, I was
Government
not,
will make arrangements.
my lord, to the query put by your lordships regarding, my lord, the assent is necessary or not, my lord, your lordships have asked me a query, I did not even answer it, my lord, everybody is picking up in the middle. My lord, my contention before your lordship says, one, it is always legislative competence. My lord, legislative competence of the state is not in question by the petitioners or by anybody. The legislature unanimously, my lord, I did not complete, my lord.
What if the government returns?
Yes, yes, please proceed. Sorry for interfering.
But the legislative competence is not in question. The legislature unanimously passed resolution, my lord, to increase it to 42%, my lord, 1. My lord, insofar as amendment of 285A, my lord, it is pending assent with the governor, 1. True. My lord, when there is legislative competence, a mere pendency does not debar from the state to act in pursuance of its legislation is my contention before your lordships, which I would like to satisfy your lordships on the reopening day or any other day. My lord, it can't be, my lord, even in Krishnamurti, I'll just read one paragraph in Krishnamurti. My lord, Krishnamurti, we have appeared before this honorable court. I'll just read one paragraph of Krishnamurti, my lord. While 50%, I'll just read it for your lordships. While 50% shall be the rule, it is necessary not to put
Please see.
out of.
1 minute, sir. What is this kind of argument? We are hearing Advocate General, you are disturbing.
I'm absolutely at a loss.
Yes,
My lord,
please.
while 50% shall be the rule, it is necessary
Which
not to put out of consideration certain
which-
extraordinary situations inherent in the great diversity of this country and the people. It might happen that in the fixing and remote areas of the population, inhibiting those areas on account of their being out of mainstream of national life and in view of the condition peculiar to and characteristical to them, need to be treated it in a different way. Some relaxation of this strict rule may become imperative. My lord, these are various contentions which we could write through days before. There is no hard and fast rule. My lord, insofar as this state is concerned, it is this situation where empirical data is there was never considered by the Supreme Court at any point of time.
Mr. Sudarshan Reddy,
50%.
you have decided to amend section 2. You did not go for subordinate legislation directly. You have chosen to amend 285A. Amendment has not taken place. Pending amendment, where is the question of issuing GO? How can you go beyond your?
As of now, if you want, you can get instructions from your state, whether it can differ up to 6 is a question. Then, and also take a decision whether elections can be postponed. Only thing is you'll have to file an extension petition.
That's what I wanted to clarify, Lord. They need not even use the words postpone. Lord, if they don't give concurrence till 7th, that's enough. Lord. Because today the steps are that the election commission will send them a letter. Then they will have to say that all arrangements are made and we are giving concurrence. And today, Lord, this 42% is reserved. Lord, they will also, actually speaking, they require some time. Which particular case, which particular seat will go to SC, which particular one will go to BC. It takes time. This is what they have been saying. When we have approached the Supreme Court, your lordships were part of it. And then the election commission said, we can't do anything unless the state government gives a concurrence.
Consent.
So today that consent and concurrence, it can be it can be postponed till 7th for a next 1 week period. That's enough, my lord.
Have it on any day,
We
my
are not
lord.
postponing the elections.
I can get my instruction,
Postpone it for 2 years.
Please get instructions, Advocate General. We are not coming in the way of your noble cause of enhancing from 25 to 42 or whatever you want to do. Do as per the law, that's it. It's a matter of only 2 months or maybe 1 month. For the present, since it is a house motion, you'll have to get instructions, don't do anything till 6th. Next.
Lordship, may I have it on any day, my lord. I'll get my instructions. And so far, my instructions are concerned. Apart from instructions, my contention before your lordship.
We have heard, that's a route, that goes to the root to Advocate General. Try to understand.
My lords, even if the assent of the governor is not given, my contention before your lordships that in view of the legislation, we can go along with this. Apart from that,
Your lordships may decide the matter on that aspect.
your lordships may want us to get
He wants,
instructions. Any day, your lordships.
We have difficulty in.
So you are forcing us to pass stay orders. What is
No,
it?
my lord, your lordships may have the instructions on any day and for the purpose of instruction.
No, right now you can get instructions. What is it?
Please get instructions within
5-10 minutes.
15 minutes, 5-10 minutes, because
No, I try to contact them, my lord.
yes, you give some undertaking that the election process will be deferred by 10 days, that's all.
I'm
So
not
that,
giving any undertaking, my lord. I'll call my lord, the secretariat and find out, my lord. I can't give any.
Yes, please find out and give
We
undertaking.
are not asking you to give any undertaking.
I'll find out.
Perhaps I am stretching myself and saying that even undertaking, they may only say the process will take some time. That is enough.
1 minute.
For a week's time. That will take care of.
Yes, Senior Vidyasagar sir. Law is very clear on this subject. Until unless 285 is amended, they can't do anything. The Parent Act should be, then the question of subordinate legislation would arise. So, only thing is they'll have to file an extension application in the 2661 of whatever
For
case.
the next single judge.
And what is a
That's only,
procedural?
that's the procedure.
Procedural. Because
So that-
under the act, unless they give a concurrence, I cannot be compelled to conduct the elections.
That's what I
And there
said.
is a necessity because
Act on. Act itself
Don't
says.
hurry things so that you end up into legal issues, legal problems.
because elections were held in 2019, long back.
2 years is, so many years pending to.
Oh,
10
so many
years.
writ petitions we have argued before the 11th Second Judge to expedite.
It's been pending
So-
for
That
years.
repetition orders are before a single judge.
Before the single.
His lordship also sitting single judge. Municipalities matter came before your lordship. Panchayat matter came before the other
Both
bench.
municipalities and panchayats elections are.
Simple petition for extension.
Yes, that's, any other advocates who want to add that, advocates who are supporting BC cause, that's a
Yes,
good cause. Yes,
may I submit, my lord? I am Prabhakar Chittoor.
you can say so, some things, still Advocate General gets some instructions. Yes, you want to add anything?
Lordships, with
I only
great
want to
respect
add one thing before my friend reacts. Probably you would not have heard. It's not as if the quota as BCs is being challenged here. The challenge here is, if you take this, if you implement this, you exceed 50%. That's our problem. Not that the X community is given more or Y community is given less. That's our
My
thing.
lord,
That's the problem today.
may I say one thing, my lord?
Yes.
If you're with your lordship's permission, may I say one thing, my lord? May I say, my lord?
Anyway, till Advocate General gets instructions, we can hear you.
My lord, there is no such a Lakshmana Rekha, my lord, that the 50% cap should not go beyond it.
Okay, that's not an issue here. What we have
Yeah.
argued, the 285 amendment is pending before the governor. And
Yes,
before
yes,
consent
yes.
being granted, can the state government go ahead with this? Joe is the only question that goes to the.
It appears, my lord, that March 30th was the day when that was sent to the governor. March 30th, it appears, my lord, it's subject to the correction by the learned Advocate General. What we have learnt is that was sent on 30th of March. So therefore, it is almost
31st August, not March. 31st August. Next.
May I submit, lordships? The Learned Senior Council has been appeared before your lordship that they didn't challenge any rules.
ఈ లీగల్ పాయింట్ కి
statutes.
చెప్పండి సార్. 1 minute, ఈ లీగల్ పాయింట్ కి చెప్పండి. Until unless 285 is amended, it is pending for governor. How can this fine get proceeded?
Allow me to 1 minute, lordships. Allow me
Yes.
to 1 minute, lordships. The Learned Senior Council appeared before your lordships by challenging the GO. Neither they challenged the rules or any statutes or any constitutional validity of acts, lordships. And under these circumstances, with great respect to this honorable court, with great concern to this honorable court, writ rules 14A sub rule 6 has categorically stating that, my lord, this matter would go to the learned single judge. With great respect to this honorable court, with great concern to this honorable court, I may be permitted to read it that 14A Roman
1 minute,
6.
sir. 1 minute, sir. We are not hearing this case on our own. This is allotted by Honorable Chief Justice as a master of roster. So our hands are tied. Okay, don't argue all those.
But
things. Next.
rules are in force.
Okay, forget about all this. You can go and complain to the Chief Justice. Why he has
I am
questioned?
very sorry, my lord, so that I said that with great respect to this honorable court, with great concern to this honorable court.
Sir, Prabhakar, 1 minute, 1 minute.
Obliged.
Advocate General point. Any other counsel? So many persons are online. Nobody is saying anything. Feel Advocate General, because we are getting bored. You must say something, no? Yes, Ramesh.
Point out. If you see the amendment also,
Yes, we have seen
it
that.
is there. No, the proposed amendment also
94.
says that we will make it in tune with the demographic requirement. But then they don't, they can't get away with that Supreme Court judgment which said we above 50% cap.
You will see.
My- My lords, this is Ramesh Chilam.
They have mentioned this
Yes,
bill in
that
the
is
GO.
the
Where
first-
is the-
This is the first hurdle.
And proportionate reservation.
where is the question of issuing this GO, awaiting the assent of the
This
government?
is the first hurdle. The next hurdle is
Let
that
them grant this hurdle first.
legislative has taken care of it. See that they don't get over, they can't get over the 50%.
Yes, any counsel.
And what learning Advocate General was
My-
reading
My lords, this
was
is Ramesh
summarized in the
Chilam.
last para of the same
Actually,
judgment. The
my
last
lords,
para-
actually, the state government, my lords, by way of the ordinance,
Online, no?
July
want to add any
15th,
point.
2 World Cups have gone by.
1 minute, just 1 minute. Councils are appearing online. Still, Advocate General get some instructions. If you want to add anything, this is a basic legal issue we have raised.
Yes.
Without amendment to
And-
285, anything, anybody wants to say anything, you are entitled to say.
On legal issue, Milord, which my learned senior counsels were referred judgment, Vikas Kishan Rao versus State of Maharashtra, 5 judges bench judgment, Lordships. Para 63, I may be permitted to read it, Lordships.
Read.
As noted earlier, social and economic backwardness does not necessarily coincide with political backwardness. In this respect, the state government are well advised to reconfigure their reservation policies, wherein the beneficiaries under Article 243D subclass 6 and 243T subclass 6 need not necessarily be contemporaneous with the social and economical backward classes for the purpose of Article 15.4 or even the backward classes that are underrepresented in the government jobs. For the purpose of Article 16.4, it would be safe to say that not to all of the groups which have been given reservation benefit in the domain of education and employment need reservation in the sphere of local self-government also. This is because the barriers to political participation are not of the same character as barriers that limits access to education and employment.
Prabhakar, you are not understanding why you are reading that. Try to understand. The state government, what it says is, it intends to amend 285 and it has submitted that bill before the governor. Governor has not given assent to that particular bill. Until unless he gives assent, it will not become law. If it is not law, it can't be implemented. That's the only question. Please answer that. That's only, that goes to the root.
My lords, may I add, my lords, with lordship's permission, my lords?
Lordships,
Actually,
one sentence I can complete, Lordships. Ramesh Okan.
Oh, sure.
This calls for some fresh thinking and policy making with regard to reservation in local self-government. This is my humble submission, Miller. The government is having in this welfare legislation in the self-government having power to make the policy. This constitutional bench judgment at para 63 stated. That's my humble submission with great
The
respect.
beneficial legislation, it did not be sent to governor. Huh? What is this kind of argument?
Lordships, the Honorable Supreme Court 5 judges bench, which has stated, I submitted before your Lordships.
Taken care of.
As long as 285 is staring at you, as long as 285 is not amended, you cannot come up with this. And the Supreme Court.
In fact,
If 285 is amended,
para
then
63
perhaps
favors the merits.
we can go into the merits of the case. We must clear the first hurdle itself, said, must clear the first hurdle.
No, but his lordship.
That's the reason we are not setting aside that you are anything. What all we are saying is, let the government file extension petition before single judge seeking extension of time for conducting Panchayat Raj elections and wait for the 3 months in view of the latest judgment of Supreme Court. If no assent is granted by the governor, it becomes a law, then you can do whatever you want. That's the point. Suppose if we stay this, set aside this, then it comes back to the square one. Again, this 1 minute petition. So much of exercise state government must have done. It all will go in waste. You must also support the petitioners. If you want this benefit, it should be in accordance with law. Because this exercise of GOMS number 9 is not in accordance with law. If you want to pour some life into 9, you must wait.
How can we support, Millard? For the past 75 years, we are not in the self-government in local bodies, at least 30 to 35% Lordships.
Right. Mr. Prabhakar, we are not on merits. We are on
Legal issue.
legal issues. Legislative competence is an issue here.
My lords, may I submit, my lords? This is Ramesh Chilla.
Yes.
My lords, actually, the ordinance was sent to the governor, my lords, on 15th July, my lords.
అయినా 3 months కాలేదు కదండి.
Yes, 15 more.
Yeah,
As your lordship. Yeah, but that was delayed without no sending back, so that no the state government took the route in the legislative formulas, and they introduced the bills in the assembly in the August 31st. Just I wanted to add that no,
Of course,
even
Vijay,
before.
if the state government give concurrence, you don't have any option to, you can take some time now, because finalizing which candidate should contest from where and all those things, you are the
But I
person.
require 45 days, the day on which they give concurrence for conducting election.
So nothing will happen in this 1 week. You are not going to issue any notification.
We will be issuing a notification from that day, 45 days is
Huh?
From the date of consent.
from the date of the consent, when the concurrence is given.
No, when you will be issuing notification, election notification?
The moment they give the concurrence, because I have made all the arrangements.
With that form.
We have
Maybe,
only-
maybe in a day or two.
Yes. Because only the reservation issue and identifying the constituencies will be the role of the state government. All other paraphernalia we have undertaken. In fact, we addressed recently also letter in terms of the directions of the learned single judge that we are willing to proceed subject to concurrence.
Suppose if we say, don't touch the governor gives consent, and it will also helping them.
Time for
Learned AG has come.
Yes. AGS.
Yes, AG.
My lord, I am unable to get into contact with anybody. Your lordship may have it on Monday or Tuesday, my lord. Because tomorrow is Sunday, my lord. A little late in the evening, my lord, I am unable to contact it, my lord.
Then
Lordship
maintain
may-
status quo till Monday.
Yes.
Sir, they can't be, my lord, may I request one thing, my lord?
No, anyhow, Mr. Sudarshan Reddy, there are only 2 working days next week, all are general holidays.
Yes.
May I request one? I'm unable to, my lord, I'm not being made, my lord, allowed to make my submission. I'm appearing for the state, not for that petitioners who are there on a peevish issue of 42% and 38%. My lord, I'm not on that. My lord, elections cannot be conducted in 6 days, no matter election commission or the state. No elections can be conducted in 6 days, even if your lordships will have it on Monday also, or the 6th or Monday. Would an election be conducted in 6 days? My lord, notification, my lord, after a notification it is given, it's 45 days. 45 days time is given. My lord, you will have to identify each of the reservation points, whether it is reserved for lady, it is reserved for BC, it is reserved for SC. My lord, I'm surprised that a house motion is moved. 45 days is the notification time.
1 minute, we have understood. 1 minute. 1 minute. 1 minute. Election notification is not a challenge day, but it already moratorium day over it can be heard. Maybe senior, it's like this. Once election notification is filed, you cannot challenge. But these writ petitions are filed before notification.
yes.
So nothing will happen. So we'll have it on 6th, right?
My lord,
Yes, but-
Cases, once notification is
Till then,
filed,
status-
1 minute, sir, what is my, not able to understand. Once notification is filed, you cannot challenge notifications and elections. Now, this writ petition is filed before notification, so we'll hear on 6th. As rightly Advocate General said, elections cannot be completed within 6 days. We'll hear this on the reopening day before a regular bench, right? Post on 6th.
Obligation, I'm deeply obliged.
Now that this is fallen from the honorable court, Lord, would it be made a part of the, because what happens is any steps taken by them. Otherwise, you know, this rule of list pendants.
1 minute, sir. 1
Lord,
minute.
I'm,
Till
Lord,
then-
your lordships have put up, Lord, just as my advocate general has made a very comments, scathing comment on us that the peevish writ petitioners.
No.
But they may be peevish, but we then we also require.
If the,
Lord, it's
if the
a-
notification
One
comes
second.
tomorrow,
We'll respond.
You
We'll
have
respond.
not
But
understood.
what we are saying, your lordships are absolutely right.
Understood. 1 minute. Mayur, even if notification is there can't be challenge to that notification. These are all writ petitions filed before notification. They have to be heard and
But
then.
let it be observed by this honorable tribunal.
Huh?
Let this be an observation. Because
Yes.
what happens is the doctrine of dispendence may not apply in
Right.
case of an election notification.
Correct,
Your lordships may make it as a part of a court order
correct.
that nothing is going to happen.
Notice before admission. Post on reopening day, 6th or 8th. 8th October 2025. And it is made clear, even if the election notification is issued for conduct of local body elections, the cause in the present writ petition survives and it has to be heard on merits.
Then status quo, madam.
What is this? Pass such an order, right?
All right, done.
That's it.
Obliged. That takes care, you don't get worried.